SJC-12612, Commonwealth versus Weidman.
Mr. Reardon, good morning.
Good morning, Your Honors. Theodore Reardon for Mr. Robert Weidman. Your Honors, the first issue presented in this case is that the defendant's motion to suppress his statements should have been allowed because he was in custody and had invoked his right to silence. He was in custody at least by the time when the police told him about the statements being made by his girlfriend, who was being separately interrogated in another room. She told the police that the defendant had told her that he had seen his drug dealer with a wad of cash and that he had said, "Maybe I should rob him." At that point in time, it was 2+ hours into the interrogation. The conversation with the defendant and the detectives had been aggressive. He was not in the comfort of his own home. He was in the police station. And he was basically being accused of this crime by his own girlfriend, so the defendant then knew that the police had a witness. At that point, under JB versus North Carolina and this court's Morales decision, no reasonable person would have felt he could have left that room. Subsequent to that, that occurs at pages 101 and 104 through 104 of the transcript. About 15, 20 pages later, Mirabelli comes into the interrogation room and she directly confronts the defendant. She tells the defendant in front of the police that she had told the police about how the defendant had said he had thought about robbing the guy, meaning the drug dealer. Again, at that point, no reasonable person would have felt that they could have left the interrogation room. Subsequently, the defendant invoked his right to silence. This is at page 143, 144. During the course of the interrogation, the police are calling the defendant a liar, to which he responds, "Okay, I guess we should stop this conversation because I'm not going to give you the truth." At that point, under the Howard case, the use of the word stop, this court said that it's necessary for an officer who's conducting interrogation.
Don't we take into account tone and language, and doesn't that just sound like sarcasm?
No, he's saying that if you're not going to believe me, then I should stop.
Is this all recorded? Is this all recorded?
Yes, it was audiovisual.
Watch it too. We can figure out what the tone was, right?
Yes.
I think that statement, okay then, we guess we should stop this conversation because apparently I'm not going to give you the truth. That sounds, Justice Hutchins is right, we can't figure out the inflection right this moment, but that sort of sounds awful caustic to me and like, all right, then maybe I won't keep on talking if you don't believe me.
Well, that's a good point, but I think that follows up on this court's decision in Santos, that if there is any unclarity about whether or not the defendant is invoking his right to silence, it's incumbent under the Santos case for the police officer to ask a clarifying question, and they didn't do it in this case.
Yeah, but in Santos, it says, I'm not going on with this. That's different. Santos, the language is from the defendant, I'm not going on with this. That seems unequivocal.
There was different language in Santos, yes, but I'm citing Santos for the proposition that if there is any uncertainty in the police officer's mind about whether or not the defendant has invoked his right to silence, it's incumbent upon them to ask a clarifying question.
Now, I read Judge Billings' opinion, but I don't recall him addressing this issue. He addressed the issue of whether or not there was an invocation of silence, but he addressed one which you're not even arguing, correct?
Well, yes, this issue here, page 143 to 144, it was not raised below.
How about 101 and 104?
That was the first time the defendant invoked his...
Right, was that argued before Judge Billings? Because he was a very thorough judge, and he did make reference to one statement which he claimed was not an invocation. I don't recall him even addressing this, which makes me wonder whether or not it was raised before him.
The specific reference I'm mentioning now?
Yeah.
Yeah, no, it was not, Your Honor.
So I think he focuses on the getting tired and whatever else as being arguably an invocation, which he says it was not. But I guess the question is, the issue is whether a reasonable police officer in the circumstances would view it as a clear invocation, but if his counsel didn't even argue it, how can we say that if it wasn't clear to his counsel when he argued the motion to suppress, why should we say it would have been clear to a reasonable police officer?
I think the response to that is basically counsel should have recognized it, and he didn't.
How about the, I'm not going to keep answering the same questions? That was before Judge Billings. What?
Yes, it was. That was at pages 95 to 96. And we would contend that under the Santos case, it's similar to the language in Santos of, I'm not going on with this conversation, and that also was an invocation of the right to silence.
That was the first time you said?
Yes, yes.
Do you think that was unambiguous?
I do, but if, again, under the Santos case, if there is any unclarity, it's incumbent upon the police to clarify and ask a clarifying question.
How do you decide whether something is unclear or ambiguous?
Sorry?
How do we decide whether something is unclear or ambiguous?
Well, I would say if it was incumbent on the police to ask a clarifying question, and I don't know that you necessarily need to resolve it if there is any unclarity.
Answering the same questions doesn't mean I'm not going to answer any questions.
I'm
So
sorry?
what's unclear about that? I'm not going to answer the same questions. How do you know I'm not going to answer any questions? Is that the equivalent, do you think? You know, I'm not going to keep answering the same questions. Supposedly they were different questions.
Well, I think his point was that they were asking the same questions, and he kept on giving the same answers.
Well, he was frustrated. He was frustrated with them.
He was, and thus he's saying, I'm not going to continue answering the same questions. So
ask me some new ones. That's really what he was saying, wasn't it?
well, I think it was incumbent upon the police under Santos to ask what he meant by that. I don't know that this court needs to take a divining rod to find out what he meant. I think Santos says that the police should have asked.
But the issue is whether or not the statement's qualified or not. And in Santos, it's unequivocal, and it seems like both of these statements that you say are invocations are qualified. Certainly, I'm not going to keep answering the same questions is qualified.
Well, I think that is the point of the Santos, one of the holdings in Santos, is that if there is any uncertainty, if there is a qualification, then it's incumbent upon the police to clarify that. Now, we're contending this was not harmless error, because up to this point, that when the defendant invoked his right to silence, he had acknowledged that he had purchased drugs that evening, and he had acknowledged his presence at the scene, but he had not made any incriminating statements as far as having had a confrontation with the victim. But after he had invoked his right to silence, he acknowledged that he had had a fight with the victim and that he had stabbed the victim. He also, after he invoked his right to silence, he had consented to a search of his apartment, and he told the police where they would find the knife. And so the only evidence that there was an actual confrontation with the victim came from the defendant's own statements, and thus it's not harmless error that this evidence came into at the trial. The second issue presented, Your Honors, is that the defendant did not voluntarily waive his right to remain silent, and his statements were not voluntarily made. Now, in this case, there was a defense expert, Dr. John Deneau, I believe it's pronounced, and he testified at the motion to suppress hearing, but the motion to suppress judge ruled that the expert relied too heavily on the defendant's statements to him in finding that the statements were not voluntary. However, there was an abundance of other evidence aside from the defendant's statements to him on the issue of voluntariness. Most importantly, we have the defendant's videotaped statements to the police, in which the police say to him during the course of the interrogation that you're acting like someone who's a heroin addict. We also have that after the defendant attempted suicide at the end of the interrogation, and by the way, we don't necessarily know that it was the end of the interrogation. The interrogation stopped because he attempted suicide. It could well have continued on after that, but for the suicide attempt. But after he was taken to the emergency room from the interrogation room, and he spoke with a Cassandra Durant, and she opined, and this was immediately after the interrogation, that the defendant had impaired judgment, and he suffered from a mood disorder and substance abuse. He was brought back to, after he was released from the hospital, he was brought back to the police station, and he was seen by a Dr. Jean Tomach, who subsequently ended up recommending a commitment to Bridgewater State Hospital. She also observed that the defendant was disheveled, was jiggling his leg, appeared depressed. The defendant made statements to her about his 2 bags of heroin being used daily for years. And she observed physical symptoms of withdrawal. We couple that with the defendant's, Maribelli's, the girlfriend's statements, that the defendant acted very oddly when the police came to their apartment. He offered them a cup of coffee and introduced them to his cat. We also have the doctor expert relying upon his review of the Bridgewater records. So there was an abundance of other evidence that the expert relied upon, including the defendant's statements to him about his state of mind at the time.
At the time of what? At the time of the murder?
No, at the time of this statement to the police.
Statement to the police, which is recorded, so we can do that, or we can watch that ourselves, right?
Yes.
And we can either agree with Chief, with the Justice Billings' view of it or not,
Yes.
right? So I'm not understanding what it is that we're supposed to be doing here. If we agree with your view of it, then it leads to one result, right? But you're basically saying that that's the only relevant time was during the interrogation, right?
I'm sorry, what?
That's the only relevant time, during the interrogation. It's not later, it's not earlier.
Yes, correct.
So when these other people saw him, it was after the interrogation was over, right?
Say that last part again.
When these experts saw him, it was afterwards, right?
Yes, yes.
Okay, so what difference does it make when they saw him?
Oh, well, so...
Couldn't he have gone into withdrawal if he was going to be in withdrawal? Couldn't he have gone into it then?
Yes.
So it doesn't mean anything about his interrogation itself.
Well, I think the doctor who saw him at the emergency room immediately after the interrogation, I think, that person's opinion about his state of mind and how he was acting, I think that is relevant to how he was acting at the time of the interrogation.
Even though if we look at it, it might not be the same? You look at the videotape, if he's acting normally, you're not seeing the jiggling, you're not seeing the other things. What do you make of it then? If you're seeing things in the video that are different than what these other people say that they saw, is that true? Is it different?
Well, I think it's all evidence that the expert could consider in opining whether or not...
The experts watched the video?
Yes, he did, yes.
Okay, that was afterwards. You're saying that they interviewed him.
Yes.
When did they interview him?
Yes.
When? You
The
said one
expert-
was in the, you said that the emergency room doctor saw him immediately afterwards. Had the emergency room doctor reviewed the video?
So the expert looked at the video of the defendant's interrogation.
No, that's not my question. You said that there was an emergency room doctor who saw him immediately after the interrogation ended.
Yes.
Had he viewed the video?
No.
So he doesn't know if that was consistent with what was happening during the interrogation or not.
Correct.
Okay.
So what is our standard of review with regard to Judge Billings' findings that he said it was voluntary? He of course, had access to the video, which we can see equally well, but he did take testimony from Dr. Tomich and Dr. Dagno, I believe.
Yes.
So does that mean that he's entitled to some deference in terms of his findings, or is it a de novo finding on our part?
Well, the judge did not make a credibility determination about Dr. Dano's testimony. What he said was that he would not make a credibility determination about the doctor himself. What he said was that the doctor relied too heavily in the defendant's statements to him and accepting them as being true. And on that issue, I think you can look at the other evidence to see that there was other evidence besides the defendant's statements to the doctor. And thus, the judge's was clearly erroneous in finding that the doctor relied, the doctor's opinion was based on the defendant's statements to him. There was other evidence upon which the doctor also relied.
Mr. Reardon, are you suggesting at all that the defendant's reaction to his girlfriend coming into the room and making statements was not voluntary as well? Or would that interaction go into the calculus as to the rest of the evidence?
I think it goes into the calculus, but I think at that point, when she came into the room and made these statements to him, it shows that he was in custody at that point and was not free to leave. But also, I think at that point, he subsequently made inculpatory statements, which I would say in the whole calculus of it was not voluntary.
And is that the moment that you're saying that there's custody? Because he invited the police into his apartment, and then he volunteered, as long as his girlfriend could go with him, to go to the police station. So is that the line of demarcation?
Well, I would say originally it started out, as you just said, to be it was not custodial. He went to the police station. But I think the first time it turned custodial was when the police told him what Mirabelli said. Then she later came into the room and directly said it to him. So no later than that point when she came into the room was it custodial, but I would backtrack it to when the police told
But
him.
he had been warned, he'd received his Miranda advisement already, correct?
Yes, which we would contest was not a voluntary waiver. Right. If there are no further questions, Your Honors, thank you.
Okay, thank you. Ms. Sylvia.
Good morning, Your Honor. May it please the Court, my name is Casey Sylvia. I'm an Assistant District Attorney from Middlesex, appearing on behalf of the Commonwealth. Your Honors, the motion to suppress was properly denied because the defendant never clearly and unambiguously invoked his right to silence after he waived Miranda. And also, it's not clear at all that the defendant was in fact in custody for either of those two challenged statements, and in particular the first one. And of course, that means that there was no right of silence to invoke under the case law of this Court.
Let's focus on, now, Judge Billings didn't really spend any time discussing whether he was in custody. He sort of assumed he was.
Right. There was a footnote, actually, in the first page of Judge Billings' rulings of law, where he says it's not clear at what point that happened. At some point, it's clear that he wasn't in custody at the beginning of the interview, and at some point, he was in custody, but he said that it wasn't clear when and that he didn't really need to resolve that question.
Because he had resolved it through finding that Miranda was agreed to voluntarily and that there was no invocation. So let's focus on when I was perplexed by your statement that custody begins not only when they had reason to believe he was involved in robbing the victim, but only when they believed that he killed the victim,
Well,
especially when they knew that the robbery victim had been murdered.
Well, Your Honor, I think at that point, again, I think it's less clear with regards to that second statement. I certainly think at the point where he made the first challenge statement that he absolutely was not in custody.
Was that before or after Ms. Mirabelli came in and they had that exchange?
That's before she came in and they had that exchange. That's the one where he says during the course of some back and forth, I'm not going to keep answering the same questions, and then he just keeps talking.
And was that before, I mean, was there any communication? I guess there were persons interrogating Mirabelli in one room, and then others interrogating the defendant in a different room. Do we know whether or not what Mirabelli was saying was being communicated to the interrogating officers of the defendant?
Not at that point, I don't believe, Your Honor. They actually leave the room to find out that information. They come back in, they tell the defendant, and then then he demands to see her. He says there's no way that she'd said that. He demands to see her. She comes in, and he confronts her at that point. And this statement is made prior to that. This is a ground the
So this is before they apparently learned what the other officers were learning from Mirabelli.
I believe so, Your Honor, and it certainly is before the point at which he confronts her with anything. And by the way, she says, when she comes into the room, she says, oh, no, I was just joking, because he's confronting her at that point. And after that exchange, The defendant, who's still there apparently of his own volition, he's unrestrained, he's unfettered, he's moving around the room. The tone may have shifted somewhat at that point, and the judge found that. He repeatedly continues to say, "You have nothing," after that conversation with Ms. Mirabelli. He continues to say to the officers, "You have nothing." Trooper DeLucia tells him, "You're not in trouble." They continue to only tell him he's lying about the details, and they say, "Listen, we want to be able to rely on what you're saying. We're trying to figure out the facts and make sense of the facts here." And they actually imply that the defendant could leave in that conversation regarding whether or not they're going to get a search warrant after the Mirabelli confrontation in the room.
Yeah, I read that, but I mean, at the time that they questioned him, they knew from the victim's dealer that he had got a request for three things of heroin. They appeared to have identified the person who was the last person who the victim had visited. They knew that the victim had been stabbed to death in his car. Did the victim have any heroin on him when he was?
No, Your Honor.
So he was, whatever heroin he had been delivered or stolen.
Or taken.
Or taken.
Or stolen. And then they have Mirabelli saying that the defendant was speaking about robbing the victim. So you really think that they would have said, "You can go home now,
Well, I mean, I think it
Mr.
seems
Weidman?"
pretty clear at that point, I think it seems pretty clear the point at which things shift for the defendant, the point at which his view of the evidence shifts from, "You have nothing, and I want to go home, I'm sick of being here," to, him shifting the story to the least degree possible in order to, minimize his own culpability, is the point at which they say, "Listen, like she told us, you said you were both going to rob and kill the victim." It's pretty clear that that's the point at which the defendant saw that there was a shift in the evidence. And so that's why I suggest that's the point at which he was in custody. And that's the point at which he really was not going to be able to leave.
Does it matter that much about when he was in custody?
No, Your Honor, I actually, it's something I felt I would be remiss if I did not argue it. And so I do argue it on behalf of the Commonwealth. It's not something I would concede, but I don't think ultimately at the end of the day it matters, because I don't believe either of these statements were invocations of the right to remain silent. The second one in particular was not even raised below. Not only was
That changed the standard of review for us?
that was actually one of my next points, Your Honor, is I think it does. I think it changes the standard to substantial likelihood of miscarriage of justice. And it wasn't something that was raised by defense counsel below. It's not something that was noticed by the judge. It's something that was only noticed at the appellate point. And I think under the Leahy case, 445 Mass 481, this court said that substantial likelihood of a miscarriage of justice is what applies when an issue is not raised in a motion to suppress. So I'd suggest that even if if the court were to find that there's some issue with this second statement, which I would suggest there's not, that the standard that should apply should be the less favorable one to the defendant.
So was the first raised below?
Yes, it was, Your Honor.
But it wasn't discussed by Judge Billings, was it?
No, I found that somewhat surprising as well, Your Honor. I mean, I would suggest that may be because, frankly, both statements are pretty unremarkable in the context of the entire interview. I think it kind of speaks to how the judge, who clearly reviewed this video at some length, viewed this, that it's not something that jumped out on him. It's not something he viewed as being the real issue in the case, and that's why he devoted all the time he did to the voluntariness issue.
But if we go back to the defendant's brief, we'll see that he did indeed make that argument.
He did, Your Honor. He raised the first of the two statements. He did not raise the second. The judge also did comment upon the defendant's comment that he was getting really tired here and he wanted to go home, or he'd like to go home, something to that effect. He said that was the closest he ever came to invoking the right to silence, and it still didn't rise to that level, which I'd suggest is appropriate under the Durand case out of this court, which was actually remarkably similar, where the defendant said something to the effect of, "I'm getting really tired here, guys. I want to go home and go to bed." And that was during a 6-hour interview that was pretty aggressive in nature, which incidentally this court found the defendant was not in custody. So with regards to the first of the two statements, I'd say that it certainly was not a clear and ambiguous invocation, because what it showed was frustration with a specific line of questions, specifically these questions about the defendant's actions after the murder. With regards to the second statement, I would say that was also not anywhere near a clear and unambiguous invocation of the right to silence, and rather it was this sort of sarcastic, offhand comment. And then what this court needs to do is view in context, it's a fact-specific inquiry, and this court needs to view in context what that statement was. Just using the word "stop" on its own it's not a magic word. After Howard, it's still not a magic word. Even in the footnote in Howard where it says that the word stop should have been a red flag for the officers, this court still says it should have been a red flag in that context. And the context that was present in Howard, I would suggest, is not present here. In that case, it was a defendant who at the very outset when he was waiving Miranda said, you know what, guys, there are some sensitive topics here, I don't know, and he continues signing the waiver, but he lays the groundwork saying there are some sensitive topics, I might not want to go into. Then later on, when he makes the statement that he does about wanting to stop, even one of the investigating officers testifies that the motion is suppressed. He wasn't sure if he was invoking his right to remain silent, and the other officer just kept going. Eventually, that officer stopped the interrogation to go speak with an assistant district attorney to determine whether or not he had, in fact, invoked his right to remain silent. So I would suggest...
On the second one, right after the second statement about, guess we should stop this conversation from the defendant, Sergeant Murray says, well, that's up to you. And then he adds, that's up to you whether you give us the truth or not. So he's not saying that's completely up to you. He brings it back to up to you whether you tell the truth or not.
Yeah, that's up to you whether you give us the truth or not. I just don't think anybody perceived this as being anywhere near an invocation of the right to remain silent. Again, as Justice Lang pointed out, this is something that this court will have the opportunity to review since it is video recorded. But I think that it's pretty clear that everybody viewed it until now as being just what was sort of a sarcastic offhand comment during this back and forth dialogue between the officers and the defendant. So I would suggest that there was no error in the denial of motion to suppress on these grounds, and even if there were any errors, certainly in that second statement, that it did not create a substantial likelihood of a miscarriage of justice.
What do you say about the voluntariness issue?
Sure. Your Honor, I'd also suggest that the motion to suppress was properly denied where the defendant knowingly and voluntarily waived his rights and he gave a free and voluntary statement. From the defendant's words, actions, and demeanor, which again are based on that recorded interview, as well as Sergeant Murray's testimony at the motion to suppress regarding his interactions with the defendant, it's clear that regardless of whether or not the defendant consumed any drugs at some point during that day prior to the 4-hour-long interview, that his statements were free and voluntary. That throughout the interview, he's clear and cogent, he responds appropriately to questions, he gives accurate biographical
You
information.
see if he's jiggling? These physical movements that were noted afterwards, were they present during the interview?
Yeah, he was jiggling his leg, he was fidgety, he was smoking cigarettes. I mean, I think that's accurate. That was Dr. Tomich, who may have been Nurse Tomich, I'm sorry, but the witness that testified at the hearing, Cassandra Tomich, had said that he was jiggling his leg, and that was basically the only one of the symptoms of withdrawal that she saw was the jiggling of the leg. And I think it's something that, frankly, is a pretty common mannerism that a lot of people, regardless of whether they're on drugs or withdrawing from drugs, I think it's pretty common. If you watched, 20 interviews, my guess is some of the defendants are doing that. I mean, something that I think some of us probably do. And so taken on its own, I don't think it signifies much, except probably nervousness, because he's being interviewed in connection with a murder that he committed. It appears throughout the interview the defendant's fully aware of his own interests. He never at any point actually agrees that, yeah, I went out there intending to rob him and then I stabbed him. He comes up with a story, and he comes up with it pretty quickly once he's confronted with what his girlfriend has said about intending to rob and kill the victim, which actually provides a grounded defense. It was the basis for the manslaughter instruction that he got at trial. So it actually was something that there was a point at which he couldn't continue to maintain the same line he had. He realized what that point was, and that's when he changed the story to something that seemed calculated to minimize his culpability to the greatest degree that he could at that point. So I would suggest that regardless of the leg jiggling or the anxiety, or regardless of whether he took the 2 bags of heroin that he normally took each day at some point during that day, that doesn't negate the voluntariness of the statement. That the actual interview itself belies those claims. And that when you watch the video, and even when you read the transcript, you see that this is not a person whose will has been overborne by the officers. I'd also just point out at one point the defendant actually explained his understanding of the Miranda rights. He refers to how you sign that little piece of paper so police can use whatever you say against you. So this is somebody that quite a bit further on in the interview, probably a couple hours on, goes back to mentioning the little piece of paper, the Miranda waiver that he has signed. So I'd suggest that this is somebody that understands the Miranda waiver, he understands what he's doing throughout, and the interview itself demonstrates that. With regard to Justice Billings' finding about the defense expert, I'd suggest that he implicitly did not credit portions of that witness's testimony. He didn't say the words, "I do not credit him." He says, "I do not agree with him. It is marred by his uncritical acceptance of the defendant's own statements." And I'd suggest that that was entirely appropriate in light of the fact that it's hard to believe that defense expert possibly could have come to that decision without the defendant's own statements a year later when the doctor interviewed him prior to this motion to suppress. If all he was left with was the defendant is jiggling his leg and he's anxious and he's somebody that was a heroin addict and he reports that to other people, and he introduces the police officers to a CAD and offers them a cup of coffee, I'd suggest that there's virtually no way he could come to the conclusion he did, that this person was so under the influence of drugs or so thoroughly withdrawing from drugs that he could not have given a voluntary statement and could not have voluntarily waived Miranda. So I'd suggest that that was a totally appropriate finding on Judge Billings' part, and that this court should uphold it.
One last question. The briefs indicate, I think in the context of him trying to commit suicide, that he didn't want to go back to prison, and I guess he had been previously convicted of vehicular homicide. Yep. Did the jury know that?
Oh, no.
Okay, that's before us, but not before the jury.
Oh, no, I don't believe so.
That was only part of the motion to suppress in terms of trying to understand whether or not his
Yes.
suicide was a reflection of mental illness or reflection of a quasi-rational view that I don't want to go back to where I was.
Yes, exactly, Your Honor. There is, in the Defendant's Record Appendix, Volume 3, the transcript of the interview, the redacted transcript that went to the jury is included there. There are large portions that are redacted, including that. And I actually would suggest that for this court's understanding of the interview, it might be actually better in a way to start with that transcript, because despite the fact it's redacted, both my brother and I point out in our briefs that there is this transcription error that makes it kind of hard to understand the sequence of events when you read Volume 2, which was put into evidence at the suppression hearing first. It's very confusing, and both my brother and I do note that in footnotes in our briefs as to where that transcription error takes place.
Okay, thank you.
Is there no further questions from the panel? I would rest on my brief, and I would ask you to affirm the defendant's conviction for first-degree murder. Thank you.